from what I've told you, from my view, and you may have a different view, is a grotesque failure on the part of the people who are supposed to be supervising a criminal who stole from a citizen of the state of Nevada. Now, that's why I asked you to come, sir. All right, 17 CR 55, State of Nevada versus Royall, Marjorie Hampton-Palmer. Ms. Hampton-Palmer is on the Zoom. Can you see and hear me, ma'am?
Yes.
Okay, if you have any difficulty seeing me or hearing me, you please let me know. In addition, her attorney, Mr. Ence, is here in person, and Ms. Mazza is here in person representing the state. And also, I have some people from the Division of Parole and Probation with their counsel. So who's Tom Lawson?
That's me, sir.
Mr. Lawson, thank you for being here, sir. I'm glad you're here. And who's your attorney?
Attorney Nathan Hastings with the Attorney General's office.
Mr. Hastings, it's a pleasure to have you here. Would you two please come forward? We'll get you some seats up here. Absolutely. Make yourselves comfortable. Now, Mr. Lawson, I'm going to do a little bit to try to set you at ease here. I'm not intending to hold you in contempt. So let's start with that.
Well, thank you, sir.
Well, yeah, but I need to get some things really clear. So while I'm not intending to hold you in contempt today, I want you to know some things. One, knowingly filing a false document with this court is contemptuous. Knowingly filing misleading documents with this court is contemptuous. Knowingly filing extraneous material which wastes the court's time and which is in fact frivolous is contemptuous. Because all of these things tend to interfere with the court's ability to engage in the orderly administration of justice. Now, I know that you came into your position, I think, back in November.
Correct.
I want you to know that I have personally met with people in your position and people under your position on several occasions to try to correct some difficulties. On one of those meetings, at the time, Judge Michael Givens joined the meeting. On another occasion, Judge Thomas Gregory joined the meeting. On another occasion, I met with the individual myself to try to talk about the difficulty with parole and probation, providing the court with incomplete, inaccurate, and untimely material related to people's probations. I want to talk specifically with you about this case and give you a history of this case so that you understand it. And maybe you have a different understanding than I. And so I'm going to give you my understanding and then allow you to tell me what you believe I should understand if it's something different, okay?
Understood.
One, I understand COVID. I get it. Every court in this state has had to make adjustments, modifications, accommodations. And I think that we have all, and I'm going to speak only of this court, been more than happy to do so. You'll note everybody is wearing a mask and I've got a plastic screen around me. That's not the only way we've done this. We have people appear by Zoom and we try to accommodate people. And I certainly have made efforts to accommodate your office. But I also understand difficulties with employment and filling positions and lack of staffing. I really do understand that. Now, in this case, Ms. Hampton-Palmer was sentenced on August the 8th of the year 2017. And at that hearing, the court made it very clear that I thought that she ought to go to prison. She's a thief, she's an embezzler, She's a repetitive thief. And I made that very clear to her at the time. However, there was a negotiation entered into between the state and the defense in which they jointly recommended probation and a suspended sentence so that restitution could be accessed, accumulated, and paid for by the defendant. So in light of the negotiation, and most particularly out of respect to the victim who had tens of thousands of dollars stolen by Miss Hampton-Palmer, the court placed her on probation so that we could get that restitution, so we could respect the victim. I said at the time of the sentencing, and I have reviewed that transcript, if she is behind 2 payments, this court is to be notified. That never happened. I never received any notification that she was behind. That was ignored. Now, that's on page 16 of the sentencing transcript. Sentencing took place on August the 8th. On August the 9th, a judgment was signed, which found her guilty of embezzlement, and pursuant to the terms of the sentence imposed the day before, she was ordered to pay $20,548 in restitution to someone that she stole from. She was also ordered to pay a $3 administrative assessment fee for a DNA assessment, a $25 administrative assessment fee, and a $150 DNA fee. Sir, I'm just going through the history here with you.
I appreciate that because I'm not aware of most of this.
It's okay, sir. Again, I'm not going to hold you in contempt. I want you to know where we are and why you're here. The probation order that your division sends to the court for me to sign arrived on September 15th of the year 2017. And it was signed that day, placing her on probation.
Just clarification, sir, is that the probation agreement?
Probation agreement, and then the terms, and the court signs it.
Thank you.
Okay, yes, sir. Now, never heard a word from you. Never heard a word from your office until April 21st of the year 2021, at which time the court receives a document called Petition for Dishonorable Discharge. It's your request, and it indicates, now again, the court gets this on April 21st of 2021. And you advise the court that she's expired her probation already on March 26th, a month before. Court's never been advised that she hasn't paid her restitution, but in the body of the document, you allege that she has gone off the map. She's not reported for months. She hasn't paid, and you want a dishonorable discharge. But you're also expiring her early because you've given her good time credit. So she's dishonorable. She hasn't paid. She's gone off the map. Nobody supervised her, and you said, well, that's good. We'll give you extra good time credit. And you tell the court after she's expired. Now, that document we held because it was never served. The documents, the certificates of service that your office uses come about as a result of the previous meetings that this court has had with your office, in which we advised you that you have to serve the prosecutor and the defense attorney so that they can respond to this request for a dishonorable discharge or an honorable discharge. And you didn't have a form. And so we helped you make one, and encouraged the DA's office to get involved so they would help you make a certificate of service where all you had to do was check a box and mail it to the appropriate people. Those are the certificates of service that you now use. Now, because it was never served, and again, this document says she stopped reporting, I'm quoting, She stopped reporting May 13th of the year 2020 and had a balance of $15,938. So a year after she stopped reporting, and you never sought a bench warrant, you never did a probation violation, you never did an incident report, all you do is sit on it for a year, and not you personally, sir, but your office, which you're responsible for, and then tell me a year later, hey, we don't know where she is, and so we just want to discharge her, while a victim remains out $15,000. Now, because that request was never served, and because we sat on it and gave you time to serve it, and you never did, on July 21st of the year 2021, that petition was denied for lack of service. Within days, on July 30th of the year 2021, you refiled the exact same petition. Now, on that document, you attach another letter. And this is very interesting, because there's a couple of things here. One, you file with the court a false document. Your office does. It's something called an acknowledgement of receipt of hearing on the probation of hearing date on the petition for dishonorable discharge. Let me be really clear. Acknowledgement of receipt of hearing date on the petition for dishonorable discharge from probation. And it has a hearing date, which was never a hearing date in this court, of August 24th of that year. And it says, I hereby acknowledge that my failure to appear at the hearing will be noted as a non-opposition to the petition. And above Miss Royall Marjorie Hampton-Palmer's name, somebody in your office signed it. It's not her signature. It's somebody in your office who has a ID or badge number of 5611. And they have handwritten above her signature line, subject moved from last known address number on file, disconnected, division unable to locate. And they sign that where her signature goes. And then that same person appears to sign an affirmation or an approved line. I'm not sure what that means, but there's that. Then there is a letter, which somebody's signed above where she would sign. She's never acknowledged it. That date never happened. I don't even know what you were doing there. But then your office files with this court on August 27th of the year 2021, a letter which says falsely, it's addressed to Miss Royall Marjorie Hampton-Palmer, and it falsely states, greetings, you expired your term upon judge's signature. I never discharged her. There's no signature of mine that indicates that she was discharged. This is false. But it's a letter to her. Now, I don't know that you ever got it to her because you quit looking for her. But this letter goes on to say, you owe the division supervision fees of $840. It doesn't mention a word about the victim or owing in excess of $15,000 to the person that she stole from. It just says that the division wants its money. Now, we're not done yet. On August 27th, the exact same dishonorable discharge request was filed. And then it was served. And then the district attorney's office opposed the dishonorable discharge. Then we had a hearing. Then Miss Royall Marjorie Hampton-Palmer comes to the hearing. And she shows up and says, she's got a letter. I don't know if you have a copy of that. But she says she was paying the $200, she became homeless. But she kept contacting, essentially, she kept contacting the division. She reported in, got pregnant, she had difficulty with her pregnancy, she had difficulty with work, but she kept checking in. Any extra money she had, she saved. Even after being told I was off of probation, told that she was off of probation, I still saved up money. When she came here, Mr. Ence, she had $10,000
That's correct, Your Honor.
to pay in restitution, which your office could have collected if she was able to save that much money. That would have gone to the victim. And she was told, she kept trying to make appointments with your office. And every time I contacted, I had a new officer. I never knew I had a new officer. I didn't even know I was getting off of probation. I was going in with my proof to let them know everything that was going on, and the new officer never got in contact with me. I now have a 2-month-old baby. Parole and probation said they will contact me when COVID started. Before the COVID, I always stayed in contact. I always checked in to see what I did or what I was supposed to do. Now, I don't know if that's true. You may have records to that effect, but she says this. I do know she's got $10,000. So if she's saving up the money and if she's paying, there's no reason she should get a dishonorable. If she's poor and can't pay and has made a good faith effort to, there's no reason she should get a dishonorable. If she has the ability to pay and has fled probation, there should be a warrant. Instead of we give up, we just quit. And she goes on to say, every time I did leave voicemails because of the officer I had or officers, I always was sent to their voicemail. I always left voicemails, if anything. My probation officer got in contact with me by email at times. And then I went to go in and check in at times. I had a new officer randomly, which I didn't know before I went to go check in. I changed officers about 3 times. So, sir, one, I'm going to collect the $10,000. 2, apparently you've discharged her from probation, and it's hard for me to do a whole lot more. We can discuss that subject, but this, from what I've told you, from my view, and you may have a different view, is a grotesque failure on the part of the people who are supposed to be supervising a criminal who stole from a citizen of the state of Nevada. Now, that's why I asked you to come, sir.
Well, sir, it's very apparent there were a number of failures on the part of the division of the supervision of this individual, and for that I truly apologize to the court. It is certainly not a reflection of our level of respect and I guess the desire to provide the service to you and to the public. But I am truly sorry. I have brought the documents requested, and perhaps I should pass those out and we can kind of go over those as well.
I'm happy to take a look at anything that you have, sir.
And so in the packet, there is the record of contact that you asked for, and then that's multiple pages, and the last 2 pages of the summary of the payments received. The $10,000 you referenced is referenced in there as well as an accounting of the good time credits that were accumulated over the period of supervision.
Could we pause for a minute allow me to look at what you
Yes,
want
sir.
me to see and allow the attorneys to look at what you want everyone to see. Okay, let's just do that. I don't think it's fair to you for me to go forward with not reading what you want me to read.
Your Honor, while the court's doing that, I also have a payment receipt for that $10,000 that I've already provided a copy. to the
Who'd
state
she
on,
pay
and
it to?
I believe she paid it to the division.
Okay, very good.
So I
I'm
have a
glad.
copy for the court for your review as well.
Okay. Again, let me just look at this document. Unless there is an objection, I'm going to mark these as exhibits to this hearing. And what I'm going to do is, Mr. Lawson, I'm going to take the document that you provided me, ask the clerk to put a staple through it rather than paper clip so that we don't lose pages. And then I'm going to mark that as exhibit 1. Is there an objection to its admission?
No, Your Honor.
No.
Okay, Ms. Clerk, would you do that for me, please? And then the subject payment receipt that Mr. Ence provided me, I'm going to mark that as exhibit 2. Is there an objection to it?
No, Your
Hearing
Honor.
no objection. Both 1 and 2 are admitted. Sir, I asked you to pause. Please go ahead.
Thank you, sir. A point of clarification on the discharge petition. You had a question about the letter to Ms. Hampton-Palmer referenced the supervision fees. And staff have confirmed that that letter will only be sent to the probationer upon receipt of the discharge order with your signature. So this has not been sent to Ms. Hampton-Palmer.
Well, sir, you filed it with the court and you didn't have an address for her. It just said unknown. So why would you file with the court a letter that you can't even send out, but you're telling the judge that the judge has released this person? You see the problem with that?
I do, sir. Yes.
Okay, all right.
Okay, so if I could turn your attention, please, to the summary of the payments and fees.
Give me one, please. Oh. Go ahead, sir.
And just to provide some information on how it's oriented so that when you're reviewing the information to follow along. It starts with 2017, August 2017, and then the columns break down restitution amount paid, supervision fees paid, total paid, and then the next column over towards the center of the page, days for fees restitution. That is the good time credit awarded for that potential month. And so the two different statutes that apply, I don't have the citations off the top of my head, but however, one of them for fees and restitution says that if the probationer makes their minimum monthly payment for supervision fees and restitution or other fees that are ordered by the court, then for each month they make that payment, then they're eligible for the good time credits in the amount of 10 days. And so for the next one is for days of employment. That one's not just employment, it also includes education, work programming. There are a number of other qualifiers for that besides just flat having a job.
Yes, sir.
But the column there shows the months to which she was awarded the independent credit for participation in work or work program or associated. Then there's a total fees date. And then on the far right side is the running tally of the original expiration date being August 8 of 2022. And then as those monthly adjustments were made, it shows the, I guess, the declining or earlier date of the new expiration date.
Yes, sir.
And I guess that's a very important point to also bring up is there's a distinct difference. It's not just semantics of expiration versus discharge, because the statute is very clear that only you have the authority to discharge. However, I guess all sentences will eventually expire. And so just by the passage of time.
Yes,
And
sir.
so day by day, as that credit, we're awarded on a monthly by monthly basis, that is why the date moved forward. And then towards the bottom where we did not have contact with her, you'll notice that there are the zeros for no credits being awarded. And so the date became static. In preparing this document for the court, we did notice that there was a gross miscalculation in our offender tracking system of that expiration date. And so you referenced the initial expiration date that we reported being March 26th of 2021. And once we audited this and realized that some credits had been misapplied by our system, which we're in the process of actually replacing, the date has been modified to the actual expiration date that should have been in play in this case, being July 14th of 2021. So we've still past that date. The dates that you've given us in terms of when the final discharge summary was filed are still past this date. But I just want to provide a context of, that's the correct date.
Well, I appreciate that, sir, but isn't it also true that someone can lose their good time credits?
Yes, there is a mechanism in law where had the division provided the information to the court, then you have that authority to revoke all or any, up to all of them, I guess, good time credits for that violation. And so a new piece of information I did not have until speaking to you today was the fact that the court had ordered the 2-month notification if they missed 2 payments. Because honestly, sir, when I read the judgment of conviction, it's not included in there, so we did not have the transcripts to which to reference. And so that is something I'm taking back as a notation point, that when we make note of these sentence actuals, that those sort of things that may not appear in the JOCs, we need to make sure we track those.
But beyond that, sir, once you tell me, in addition to my order that I be notified if she missed 2 months, in addition to that, you've got months where you don't even know where she is, and you don't file an incident report, you don't file a violation report, and you don't seek an arrest warrant. You just let it go, and until you hit the date of expiration.
Sure.
And once you hit the date of expiration, I don't think I can do much.
Unfortunately, you are correct in that, sir. The statute binds your hands.
Right. And so at that point, sure, I can, we're certainly accept her $10,000 but Mr. Lawson, I want you to know, this is so disrespectful to the victim of crime. To simply take a criminal like this woman, and Miss Hampton-Palmer, you may get tired of hearing me call you a criminal, but you and I we had enough experience back when I was taking your plea. Now you've done well and you've accumulated money, and everybody, let me make this clear too. Everybody gets a chance to change their life.
And I have something.
Hopefully. And no, ma'am, you may not speak until I call on you. So everybody gets a chance to change their life. And she's committed no new crimes. And so this court is respectful of the fact that the laws of the state of Nevada and parole and probation are designed to give someone the opportunity to change their life and to return to the good graces of society. And it appears that she's made the great effort to do that. And if in fact she has, if she's right about she kept contacting P&P and was told we'll get in touch with you, or she left voicemails and all like that, then there's no reason she should get a dishonorable. If she did, we need to afford people the opportunity to return to the good graces of society. But this whole thing is disrespectful to her. It's disrespectful to the victim and to the laws of the state. And I'm hoping, sir, because there's not much more I can do in this case, I am hoping to never see this again. That's what I need you to know. And this is now the first time I've had to have you in court, but the 4th time I've had to speak to someone either in your position or your deputy about this issue, and it has never been cured. And I would like for it to be cured, because we cannot continue to have this happen, where victims are ignored and where defendants there's a request to dishonor them when you just quit working with them. You don't need a lecture from me, sir. I'm not in a position to lecture you. I respect you. But this can't keep happening. And I hope that's the message you take back to your office.
It is, sir.
Well, I appreciate it, sir. Now, Ms. Mazza, I don't think I can do anything really much here. I can enter a civil judgment, I suppose.
Your Honor, if I may.
Sir,
The civil judgment is unnecessary because the judgment of conviction specifically refers any outstanding restitution as a civil matter.
it
So
does on the
civil
very
conviction
last
is-
line of the judgment.
Yes, sir.
Thank you. Ms. Mazza.
Your Honor, I agree with the court. I believe the current statute of the law, that your hands are tied with regard to discharging this defendant here today. I would ask that there be a civil confession order here today, though, because I do know that does aid in any process if the victim were to go forward to try and collect.
Would you
that
prepare it?
restitution. Yes, Your Honor.
Mr. Ence, what would you like to tell me, sir?
I'd simply like to tell you that Ms. Hampton-Palmer, I think, substantially complied and does not deserve a dishonorable discharge. If the court's going to discharge her, I would ask that be honored.
Sir, is there anything you'd like to tell me?
Thank you, Your Honor. The only thing that I think I'd like to clarify when Your Honor says to the division, I don't want to see this happen anymore, and I believe that the division, well, I know that the division, we've met extensively on your order to show cause in terms of preparing for this hearing. The division and the department takes this very seriously. I'll point out to Your Honor that the deputy director of the department is here with us today. The one statutory kind of item that I wanted to clarify on in terms of the way that the order to show cause was worded, when there's reference to an expiration that may lead to what we might call an early release or a discharge in terms of the way that the order is worded, when there's still money owing on restitution. And I believe that this may be implicit that Your Honor already intends and understands this. If an offender were to pay the amount every month, based on what that amount might be set at, and in this case, in the judgment of conviction, it was set at $200 a month. And just doing the math, if the person paid every month based on the accumulation of 10 days of good time credits for each of those months, there would be an amount still owing at the end of the day.
I agree with you, sir. I
Okay.
agree. And if, you know, we had a very complex and lengthy restitution hearing in this case. And then, you know, there was a lot of discussion about how much she could pay every month. And I set it at 200. And if she did what I told her, I mean, I knew it wasn't going to all get paid, but I also did not want to, you know, we could take whatever the total amount is and divide it by the maximum amount of months and come up with a figure that she'd never pay.
Right.
And set her up for failure. And so I set it at 200, which was an amount lower than would have paid this off, but which would have hopefully generated actual payments. I agree with you, sir.
And I just wanted to make sure for the record. that we
And
were
nobody
clear.
would be in trouble for that.
Right.
Okay, everybody'd be square.
Perfect. Thank you, Your Honor.
Okay,
Your
Ma'am.
Honor, just to make a distinction though, if they were to ask for her to be honorably discharged at that point, and she hadn't paid that off, there would have to be a showing that she cannot pay it because of, for economic reasons or whatever that may be. So I do think that there would be requirements additional to what has been submitted in this case.
oh, I agree, because there's not a showing of poverty. You know, that's a question because nobody who's poor is in trouble in this court for being poor. And so if you can't make the payment because of your finances, you're not in trouble for that. But if you have the financial ability, $10,000 holding on to, and you don't make the payment, then you are in trouble. And but I'm going to tell you that the court concludes that what is equitable in this case, and quite frankly, this defendant doesn't deserve a lot of breaks in life for her behavior, but she has modified her behavior, and it is this court's intention to find that she is honorably discharged, because it appears to me that she made efforts to contact the division which were rebuffed and not accepted by the division, and she's given an honorable discharge.
Your
So,
Honor, if I may,
yeah,
the statute, we're looking at NRS 176A.850 is a little bit unclear on this point. And for the record, I think that just because the prosecutor has mentioned this, I'll point out that it states in, so sub 1 is honorable and sub 2 is dishonorable within the statute and how that works. Under sub 1, it states that a person who has fulfilled the conditions of probation for the entire period thereof, or is recommended for earlier discharge by the division, or has demonstrated fitness for honorable discharge, but because of economic hardship. And so theoretically, if someone had made all their payments throughout the course of the period of probation and based on the application of good time credits, that period had
that's sub
actually expired.
2 of that statute. You're right.
They would not need to be, there would not need to be an economic showing if they had actually fulfilled all the conditions during that time.
Okay, well, in this case, that's a moot point right now. It is asking the court to render an advisory opinion, which I shall not do, but which I shall let you know that this defendant will have an honorable discharge. And Ms. Hampton-Palmer, please continue to behave yourself and do not violate the law again, because you're not likely to get another probation. And I will just tell you this, in my nearly 40 years of experience in the criminal justice system, the people who are the most frequent serious recidivists, which is reoffenders, are embezzlers. And you should never go down that road again. I wish you well. Mr. Lawson, thank you for coming in. I appreciate our discussion. And I'm hoping that in the future, there's a modification to the way the division works. Okay. Thank you for your appearance, sir. Ms. Mazza, Mr. Ence, thank you to all of you from the division who came. I appreciate you being here. And let's try to move forward in a better fashion to serve the people of the state of Nevada. Because, you know, again, the division, what I tell people all the time, the division is not just there to catch you. They're to help you amend your life so that you are law-abiding from here on out. And I know that the hardworking people who are your officers, that's their goal. But I'm telling you, just letting somebody fall off the books, you know, if people aren't on probation, then they need to be in prison. If they're not going to be probatable, okay? Let's work on that. Thank you.
Thanks, sir.